Okay, welcome to this month's webinar at the Micklin Law Group. Grandparents' rights, what are they and how do you enforce them? Okay, so let me give you a little information about what to expect from today's webinar. Again, this is about grandparents' rights. It's anticipated or expected to be about 45 minutes in length. Sometimes it's a little shorter, sometimes it goes a little longer. It really depends on just how I cover each piece of information. It's the first time I'm handling this kind of webinar, so I'm not really sure. There is a lot of information, a lot of recent developments that we need to cover, so it may take us a little bit more to get through than normal. You'll notice it's a one-way communication, so you can hear me, but I can't hear you. There is or should be a control panel on the right side of your screen that will allow you to post questions throughout the webinar. Now, I'm not going to address questions during the webinar, but I do so afterwards, and I'll take as much time as necessary. But I do recommend that you post the question that you have as we go through it and not wait until the end so that it doesn't slip your mind or get replaced maybe by another issue or another question that you may have. I am recording this. I will make it available to you afterwards so that you can sit on your own and listen to it. I still would recommend that you sit through it if you have the time allotted, because I just think it's better to hear it live, and then also a better chance to address any questions that you may have directly. One last thing at the end of this, you should, I think it's at the end of this, it's either immediately at the end or sometime early tomorrow, you'll get a survey sent by an email asking you about the webinar itself. And I would appreciate if you could take a few minutes to address it, because it helps me to plan future webinars when I know the effectiveness of the ones that I'm actually holding right now. Okay, so for those of you who don't know me or haven't been to any webinars before, this is me. My name is Brad Micklin. I am the managing member of the Micklin Law Group. I've been practicing law now a little shy of 20 years. I am a member of the New Jersey and Pennsylvania State Bar Associations. I'm also licensed to appear in both state and federal courts. I have also actually appeared in both court systems. I started my law career by working as a judicial law clerk for the Honorable Eugene Austin. He was a presiding judge of the Special Civil Litigation Division in Bergen County. The benefit to that position right out of law school was to really learn what happens in the courthouse behind the closed doors, how judges handle papers, how they handle lawyers, and what they do and do not want you to do. From there, I moved on to Kessler and Associates in Clifton, New Jersey. I did complex commercial litigation for a number of years. The benefit to that experience was that the litigation I currently do is complex civil litigation, so it's similar in nature but different issues. Now my practice is concentrated in complex divorce, family law, and estate planning and litigation cases. The Micklin Law Group itself is also concentrated in these specific areas. We have two associates, Rachel Isaacs, who is our senior associate, and Richard Muglia, who is our junior associate. We have various support staff members that you will, if you deal with my firm in the future, deal with. We have Carmen, who is our client service manager. I have about to replace my paralegal, so I don't really have the name for that person. And we have a number of administrative assistants that help us throughout the different tasks that we have for our cases. Right now, before we dive into the issues of the webinar, I do want to give just a little kind of a preface, because these issues are always a very sensitive issue for the families involved. And no matter where you may stand on this issue, whether you're the grandparent or the natural parent or even just reviewing it for somebody else, it's important to remember that we're dealing with a lot of sensitive issues. First off, we're dealing with a child and children relationships, or a grandchild, for that, whatever, again, where you stand. And obviously that relationship is always a very sensitive, very intimate relationship. We're also dealing with the rights of a parent to raise their own child. which, as we'll cover throughout this, is a very significant constitutional right. But then lastly, and sort of underneath a lot of these issues, we're sometimes dealing with the loss of a child. More often than not, a grandparent's seeking a court order for visitation with a child is commonly followed by the loss of their own child. And in some cases, it's motivated by that to replace the loss, and others, it's just in order to preserve the relationship that they had. But it's important to remember that wherever you stand on this case, so that we can really understand what everybody's going through. Okay, so let's take a second and look at the background. As you see here, prior to 1965, there were not only no grandparent visitation rights, but no third party visitation rights, meaning nobody had the right to seek custody or parenting time with one's own child. As we'll see throughout this, now both parties, both grandparents and third parties, have the rights in many different ways. Third parties aren't going to be addressed here, but it is a significant issue when it comes to custody issues. So if you're not necessarily a grandparent but are seeking visitation or custody, this webinar is not going to apply to that issue, but you can contact me and we can discuss how the third party issues may relate. So what we're going to cover here in a second is how the laws have changed and why they've changed. And you'll see the next few things we're going to touch on is really the law's reaction to how the definition and type of family has developed over the last 40, 50 years and how it currently develops today. See, the first note we have is that the changes was response to the increase of non-traditional households. Now, that's a common phrase today because you hear a lot about same-sex marriages, which is the big issue in law now. But back in the 60s and 70s, it wasn't really that relationship that they started to address, but it was more of the developing single parenting relationships. As the divorce rate increases, as unmarried couples started having families, and individuals increased in their number of adoption of other children, both in this country and other countries, the type of family, the intact family unit, the husband and wife and children, really started to evolve into situations that hadn't been contemplated by either the case law or the legislature. So we started to see that recognition. Also, in the last 20, 30 years, there's been an increase in the number of grandparents that are heads of the household, meaning children, grown children, adult children are returning to their parents' home. It's, again, part of the increase in the divorce rates, also a lot of economic issues, even recently with the change in the economies and the real estate market. We're seeing a lot of people that are returning to live at home. And back in the 1990s, that was also starting to increase at that point. And then there's a rapid increase in the elderly population. This is mostly attributed to one, that just over time, over generations, people tend to live longer, but there's also been and will continue to be significant medical advancements that are prolonging life. So we have more grandparents living into older age and involved in their family relationships. And the last thing was just a recognition, as the courts and laws try to do when it comes to children, that there's a significant, or can be a significant, benefit by having extended relationships like with grandparents. And when you divorce natural parents, you'll even see this law starting to recognize that the usually non-custodial parent, who is still commonly a father, is getting more significant parenting time than in the past, because the courts are starting to recognize the benefits of these types of relationships, in two-family household relationships. All right, so let's go back to sort of where most of this began. The case we're going to talk about was a very, very significant case. Still tends to be a very significant case because it's sort of the starting point from where you look to, one, understand grandparents' rights, but also try to figure out where it's going to go. So there's a Supreme Court case of Troxel versus Grandville, the citation you'll see up there. This was a case in which a father had 2 children, he was unmarried, and he had committed suicide. So the grandparents, the father's parents, were having parenting time, visitation with the children. And once the father committed suicide, that visitation continued. Now, there was a certain point in time where the children's mother remarried. Now, remember that the mother and father were not married originally. The father, once he passed, the mother remarried or married somebody who adopted these 2 girls. And following the adoption, they sought to stop or did stop the grandparents from visiting with the children. Now, the trial court granted the grandparents visitation, and it went to the United States Supreme Court, and they overturned the statute. Now, it was actually a very significant decision in that, for those of you interested in the law, each judge on this court actually wrote his or her own opinion for this case, which is very uncommon. I think it suggests that even at that point, when the first challenge came, they knew that there was going to be a very long tortured history, or not tortured future, to this issue. And I think everybody had such strong opinions that they wanted to make sure to voice it and sort of give guidance for all of us in the future years to come. Here we are almost 15 years later, and the issue is still developing. So getting back, they overturned the statute that Washington had, which basically said that all you needed to show was that the parenting time was in the children's best interest. That's a very common phrase for parenting custody issues. You'll still see it in New Jersey as well as many, if not most, other states. But the reason that it was struck down by the Supreme Court was they felt that it was too broad of a standard, and it actually infringed upon the individual parents' rights to parent their own children. And you'll see that's a battling issue that is an underlying theme on all these custody parenting time issues, is the constitutional right, or what is deemed to be a constitutional right, to parent your own children, free from interference of other people, and even free from the interference of the court and legal system to some extent. So what exactly did this court hold with regard to this case? They didn't necessarily say that best interest test is abolished or inappropriate, but they sort of meant that that's the basement level of proof, meaning that at a minimal, that's, you need to show that, but that you need to have more than that, or there should be more than that. Because thinking about it in 2014, that's a very vague standard. It's very difficult to prove or disprove. Most things you could argue would be in the child's best interest. And I think that the direction the Supreme Court was heading at that time was the accurate way to really look at it. So now most states have their own requirements. Most of them that do allow for it will have the best interest theme involved in it, but that there's much more above and beyond that needs to be demonstrated. There are some states that have deemed it to be unconstitutional to have a grandparent visitation or custody rights over the natural parent. Again, that's probably premised on the fact that it's a constitutional right. I have my doubts about whether or not those statutes will actually stay. It's hard to say anything with a clear-cut, bright line when it comes to a child's best interest could be unconstitutional, but I guess we'll see over time. All right, so moving on a little more again about this case. The purpose of the court, or the rationale, as I mentioned before, is the court has held both in this case and in many, many cases, decades before it, that a fundamental constitutional right that a person has is to raise their child and to have a relationship with their child. So the courts are always very reluctant to step onto that right. And we'll discuss later in this webinar how and when they do, because obviously everybody attending knows that they do to some extent. But generally speaking, both this decision as well as the Constitution and the laws of every state starts with the presumption that the parents are fit. they're the ones who are charged with making a decision of what is in their child's best interest. So the courts are hard pressed to step in and circumvent that decision. One, because it's inappropriate. Two, it's not really something easily you can do. A parent is there day in and day out to some extent, knows the child and the need. So it's hard for a court to step in and say and second guess that, I guess is the best way to put it. And here I mentioned just they're reluctant, all courts and legislatures are reluctant to pass laws that specifically impede on the right to raise one's child. But that doesn't mean that nobody does. Obviously, many states have, and New Jersey is one of them. We do have a statute that specifically talks to grandparent rights. It's NJSA 9:2-71 or 7.1. The statute itself provides that you have the right to file an application for parenting time. What it does seek to spell out is what needs to be done. And the purpose between having a statute is it takes the power away from judges to make their own standard. And by passing a statute, they're forced to follow it. So the burden of proof at the time the statute was created, and it still is that you need to prove that by a preponderance of the evidence, it's in the best interest of the child. So here we see we are still taking the best interest standard that the Supreme Court is suggesting under the Troxel case. It may be inappropriate, or at least at a basement level, and it is incorporating that, but it's changing the burden of proof. Now, preponderance of the evidence is kind of hard to explain because there's no specific number. You can't quantify what is a preponderance, but the way that most judges will explain it is if you had, let's say, a scale of 50% and 100% of the evidence, you'd have to show a little more than 50% that it was in the child's best interest. What that is or how that's done will really change on a case-by-case analysis. Now, there was one exception to this, at least at that point in time. There's a rebuttable presumption. If the grandparents were the caretaker of the child, the full-time caretaker, then we had a different situation because it's not necessarily that they're just grandparents, but they're sort of the parents. If they've had a full-time caretaker, a term we'll get into a little bit more in future issues of this webinar is called, it's a Latin phrase called in loco parentis, which means you're standing in the shoes of the parent or as the parent. So the standard really becomes you are the parent, and that's why there's a rebuttable presumption. If you can show that you're entitled to continue the relationship, it's deemed to be in the child's best interest. Okay, so now the NJSA statute has several factors. It's a significant, and in my opinion, a very rigorous standard that needs to be met, or at least that the court will look to when deciding this. And I think that the reason it's so rigid is because of at least at the time of Troxel and the passing of our statute, many feel that grandparents don't or shouldn't have that much right. And if they're going to seek the rights, to make it very limited. So the first factor, the relationship of the child and the grandparent, obvious point. The second is the relationship between the parent and the grandparent. And this is very important because how the grandparent and parent interact with one another will have an effect on the child. In order to co-parent, whether it's with grandparents and a parent or two parents, generally you need to have cooperation. So if the parent and grandparent don't get along, don't cooperate, it's likely to affect and harm the child. So I think this is going to be a very significant factor that the courts weigh when determining when to permit grandparent parenting time or visitation. Number three is the amount of time since the last contact with the grandparent. Obviously, the further away it is, the less likely the child is to be attached to the grandparent, and therefore the less likely any loss from severing that contact. The effect visitation will have on the child and the child's parents. Number five is the time sharing agreement between divorced or separated parents. So obviously this doesn't always apply to cases, but What this means is if you had a mother and father that divorced and had a parenting schedule, and let's say it was a typical alternating overnight weekend schedule, if a grandparent were to step in and ask for a parenting time schedule or visiting schedule with the child, I think the courts would look under this guideline to the schedule that the two parents had, because that would suggest that that's what they think was good for the child or children. So at best, they would replicate that for a third party or a grandparent that's seeking parenting time. So it's just something that they can look to. Um, Number six, a good faith filing of the grandparents. And this can be many issues. And again, it's going to depend on the circumstances of each situation. One is going to be, are they truly seeking to continue or build a relationship with the grandchildren? Is it really just about the children? A lot of times they'll look at this factor as to whether or not the grandparent is seeking parenting time because they do not like the other parent. They may not agree with the other parent's choices. And again, like if it's a divorce case, for instance, the grandparents may try to impede upon the ex in law's parenting time out of contempt for their child having gone through a divorce. It's sort of a retribution. And lastly, like I said when we started this, a lot of times there is a loss of the grandparent's own child, and they may be trying to fill that void. And while that's certainly understandable, doesn't necessarily lend to interfering with a parent's right to parent their child. So court needs to look under this requirement and a lot of different issues that will vary depending on the circumstances of the case. And then seven is if there's any history of abuse or neglect by the grandparent. Obvious, that's a factor. And then the last factor that they generally will have in almost every statute in New Jersey is any other factor that's relevant. And again, it is good to have those things. There are going to be many times where there's issues that don't fit into these 7 boxes that they give us. So they put sort of this catch-all, but sometimes it creates a lot of difficulty because you can argue anything. If you don't satisfy enough under the first 7, people will often use the last one as a way to sort of make a catch-up and make an argument more compelling than it really is or should be. So let's look a little more focus on to the purpose of the statute, what it's looking to accomplish. The focus is always on whether there's harm to a child, not the grandparent. And usually the harm is either from giving parenting time or from taking it away. More often than not, they're going to look to, is there harm from removing the grandparent from the child's life? It's always going to be this type of a focus, whether the laws change or not. The best interest of a child usually comes down to what's going to hurt and help. The prima facie case, until we get into some of the recent case law, which hasn't really changed a great deal, but you have to show serious harm if it's denied, psychological or physical harm. And that's a very challenging burden of proof because until something happens, it's hard to measure what will happen from it. And generally, at this point in time, or not this, but at the time the statute was passed, the only way you could really do that would be with an expert report that was sort of a hypothetical, that they're anticipating what may be the harm. And that was, again, only if the expert or the grandparents were able to interview the child. If you think about this logically, if you have a grandparent who's trying to force a parent to allow visitation, it's unlikely that that parent's going to allow you to take the child to an expert to review and write a report to support their action in court. So you were hard pressed to actually obtain evidence you could show the court to substantiate that serious harm would come. Now, if you did, the court would then turn to the best interest test that's placed in the statute. But getting to that point was very difficult. Now, along with passing the statute, they also passed this provision under NJSA 52:27D-9.1. And this was an interesting development because it requires the Department of Community Affairs to develop and disseminate a program that would allow grandparents to be aware of their rights. not only to advise the grandparents of the rights, but to advise parents of the benefits of contact with extended family members or third parties. And the reason I think it was a little odd that they put this in here, because at the same time that they're codifying a statute to make parenting time more difficult, they're requiring the state to provide information telling people that they had this right. So they're making it more difficult, but telling more people about it. And when you when the government or the state provides a pamphlet to grandparents saying you have grandparent rights, I think it almost would mislead people to thinking it's not a very challenging burden, and they would move forward more likely because they had this information than if they didn't know how to find it themselves. I mean, I can guess at why I think they might have done this. I think part of it is because partly they're really trying to help children by encouraging the families to provide this without bringing it into the legal system. And I think they're also trying to discourage litigation. Most children benefit by having these issues decided outside of court. So, but nonetheless, it's what New Jersey wanted to do at the time that they created the statute. So let's look at what's happened in New Jersey since both the statute and the Troxel case. And there's been a good deal of development in grandparents' rights, and even recently. And I'm going to walk through what's been going on, because I know a lot of people seem to think that there are not grandparent rights in New Jersey. And I think there's the reason that that happened is at one point in time, and we'll go through this, it was relatively easy to seek parenting time back with Troxel and just the best interest standard. Then the law passed saying that you had the preponderance standard. And some of the cases we'll talk about in a second show that they made that even a little more rigorous. So the impression to people is that they don't exist. People take it that they don't have the right, which has never been the case. You've always had the right. It's just been a developing right that was more or less easier and more difficult at different points in time. And we'll see at the conclusion of the evolution of New Jersey case law that there's some recent decisions that seem to be chipping away at the rigidity that the law has had with this issue, and may suggest it's not going to be as difficult in time to come. So let's look at New Jersey's first case, Moriarty versus Brandt. This was a 2003 case which kind of mirrored the Troxel issues about having to show it was detrimental to the child if you denied parenting time. Here we're seeing the reversal of what used to be under Troxel the best interest. Now it's got to be detrimental. It's got to be harmful. Not that it's going to be best or helpful, but there's actually harm. And this was motivated by what I keep pointing out, the state's recognition that a parent's right to parent their child is a constitutional right that should not be impeded, or at least before impeding it, there needs to be a compelling reason for it. And we see that even through the next 2005 cases that follow that, Mazzari versus Cannon and Daniels versus Daniels. In the Mazzari case in 2005, the grandparents were denied parenting time or visitation because they argued that the harm that would suffer was the potential loss of happy memories. Now, I sit here and maybe my view is a little different. I would think, well, of course, that's never going to be something significantly detrimental to a child to change parenting time. But this case illustrates a problem that grandparents were having, and that it's very difficult to establish what could be harmful, especially if you're in the relationship. You don't really know what harm is going to come until it's over, and you don't want to be put into that space. So I think in this case, they made the best argument that they could, and it was obviously not close enough, and it was shot down. Daniels versus Daniels in the same years decided they also denied, even though in this case there was significant parenting time, because the standard requires something substantial, very substantial, not just a harm, but a preponderance that there's going to be serious harm to the child. So even in this case where there's a tighter relationship, they still denied it, saying that there was not enough of a showing. Now, for those that are interested in how the legal process works, if you notice it, it's not just a strange coincidence that there are two cases in 2005 that dealt with this issue. The way that appellate courts and especially the Supreme Courts handle their cases is they will wait until a number of cases with similar issues are filed before they decide whether or not to hear and decide a case. So when enough cases have been filed, a decision can have a much broader stroke on the issue, and then they'll start taking cases. So when you see these two, 2005, and you also see it, many other issues, it's not a coincidence, but it's also not a plan. It's generally how the courts will work so that they can address more issues with fewer cases. And then we have the 2007 case of Rente versus Rente, where they continue to deny the grandparents' rights, even though the grandparents were significantly involved for the first 2 years of the child's life, babysitting and having a relationship. And while 2 years may not sound like a lot to those who parent, 2 years is believed to be one of the strongest bonding time periods that a child experiences. So the grandparents were involved for this incredible bonding period and still denied the parenting time. And the evolution of these cases, 2003, 2007, and even shortly after that, it shows the state and the courts increasing reluctance to give parenting time, or I keep calling parenting time, but it's really visitation, to a grandparent, to a third party. So let's look to some more recent cases. We have Rice versus Van Hart and Zalen, which is a 2012 case. This is a case that goes to the in loco parentis that I was discussing a little earlier, where they found they set forth the requirements to find when a grandparent actually stands in the shoes as a parent. They call it a psychological parent. And the requirements still are very rigid, but at least it gave you sort of a roadmap when you had a situation where there was significant involvement, but yet you might not be able to show the harm. So first, it had to be that there was a consent and fostering of this grandparent or parent-like relationship. It's not just going to be something that happened as a matter of course, like perhaps one parent absconded and left their child with his parents or his or her parents, and over a brief period of time, a bond developed. It had to be something that was actually planned, and they all sort of fostered. The child and the grandparent had to be in the same household, so they needed to be living and taking care of the child. They had the obligations of parenthood, meaning they had to be acting like the parent, not just living in a two-family house where maybe the child was on the first floor and they lived in the second floor, but they actually had to be parenting. Now, well, the obligations of parenthood under this test would depend a lot on the child's age, but obviously it's common sense of whether or not you're bathing, preparing meals, taking them to school, extracurricular activities, babysitting, things like that. It had to be for a significant amount of time so that the child would have actually bonded and became dependent on this grandparent as they would a natural parent. Now, this case is an expansion upon the earlier cases in New Jersey, where it shows that we're slowly moving beyond just the rigid, needing to show a detriment to the child. But it wasn't a great expansion because the fact pattern in this situation is not as common when it comes to grandparent visitation, and it's also a little more common sense that if a person has had a child living with them and they've been caring as if they're the parent, anybody's going to have the right to seek even custody, not just alone the visitation schedule, under New Jersey's third-party custody statute. So this case was a start, and it's not that old, but it still doesn't change the great deal of the rigidity that we've been experiencing up to 2012 with showing the harm. So we look at 2013, and even there, in this case, you'll see Copal versus Pearson. The parents were in a more substantial relationship with a child for 6 years. They even had legal custody at certain times and cared for and raised a child as a child. They were deemed to be the psychological parent. Now, this case really just built upon the last case. And again, it's sort of the issue I mentioned a moment ago, where the courts wait for cases that are similar. It allows them to make decisions that carry forward. So we'll see that this decision really didn't change much. We still were left with a statute that says you have to show detrimental harm, and the difficulty in getting that was very difficult. And the reason I may have skipped over, I meant to explain this. The reason that it was so difficult, or is so difficult, um, getting this is you needed to have an expert, or the only way you could really get the court to give you a visitation schedule as a grandparent back 2012 and back is if you had an expert report that spoke to the harm. You're never not likely to get an expert that gets access to the child, and one that could really postulate what could be detrimental in the future. It was very difficult. It's sort of like anticipating what's going to happen when you get in and drive your car. You're going to have an accident or not. So that inability to have independent, objective evidence to show a harm in the beginning of your case when you're first going to court made it very difficult to be successful. So now we have RK and AK versus DL in 2014. This case addressed a number of different issues. First, it allows parents to decide in an agreement, like a divorce settlement or a parenting time agreement, whether or not to allow grandparent visitation. Now that kind of cuts both ways. If the parents put it in, then it supports allowing the grandparent later to come in if there's a falling out or a passing of one of the children, because putting it into agreement would suggest that the parents felt it was in the child's best interest at the time. But now the absence of it, because it's not, again, this is 2014, so up to this point, most lawyers, if not all lawyers, nobody was thinking of putting it into settlement agreements unless there was something in place at the time. So you can now argue the absence of the provision suggests that the parents didn't want grandparent parenting time or visitation. So it was an expansion. But the most significant development that this case established, which I really think is going to be one of the most significant changes most recently as we see grandparent visitation cases developing, is it allows two things. One was the discovery, meaning you file in court for grandparents' rights, and they will now or can now allow you to get and exchange information to decide the issue. So a moment ago when I was saying it was hard to get an expert because you didn't have access to the child, now the courts are saying you need to have access to the child. In order for the court to make this decision, the court needs the information. So we now need to exchange the information and we need to get reports done. It's a huge, huge step for those who have tried in the past, because quite commonly, like I've been saying throughout this, is you couldn't get access, you couldn't get the expert report. But now, also more importantly, is that in addition to an expert report, you can also have a fact witness testify or write a report about what could be harmful to a child, which is a tremendous development for those that are seeking grandparent visitation rights, because it's much easier to get an independent fact witness, friend, relative, babysitter, family doctor, to write about the harm that could come from the child from what they've witnessed. They don't need to be educated, they don't need to be licensed. Not only does it make it easier to get the report, it significantly cuts down the cost that you could incur in trying to get these rights, which in many cases is a burden that grandparents have to overcome. So the RK case in 2014 really made large expansions in the grandparents' ability to get access to the court and to seek their visitation. It has not changed the standard, but it's improved one's ability to get into court to look at the issue, to attempt to prove it. So you don't have to prove it in the very beginning. The court will bring you in and actually investigate the issue with you, which is the best way to handle an issue like that. So I think this case, as long as it stays as good law, is going to significantly change how grandparent rights are viewed. And I think we're going to start to see more changes in that, with the increase in same-sex marriages. As I said at the beginning of the webinar, Grandparents' Rights grew out of um, newly developing types of family and recognitions of the new type of families that we have. And this is a significant one where in the past they couldn't marry, and now many states are allowing same-sex marriages. So you're going to have a lot of new grandparent issues arising from these relationships. So to see the law expanding in New Jersey, I think, is a good sign for those seeking to get grandparent rights. Now we'll take a few minutes real quick to look at just some other issues where grandparent rights are viewed or where are significant. These aren't in an attempt to get grandparent rights, but it just shows that courts are starting to look more towards grandparents as a very significant contribution to children. First, with relocation, if anybody's ever tried to relocate to another state with a child, one of the factors court will look at is how does it affect the relationship with extended family members. Now, again, this doesn't mean that this is an issue for getting grandparents' rights, but it means that if you wanted to move with your child and there's a grandparent that's involved or a family member, extended family member that's involved, the courts are going to look at whether or not that's going to harm the child. And that could, in fact, be a reason you're prevented from relocating with your child. There's an O'Connor versus O'Connor case in 2002, which is part of the case law that determines the relocation standards in current situations. And it stresses the need to review the child's relationships with extended families and how that's going to affect them. And lastly, the support network. And again, this is still within the relocation issue. If you're looking to relocate, they're going to look at what is the support network that you have here and where are you going, what we have there. So if you're here and you use your grandparents for daycare and babysitters, or the other parent did, when you seek to relocate, the court's going to question whether or not you're going to have that same type of support system or network where you go. So if you have a tight family relationship here and not where you're moving, it could prevent it. And conversely, if you're moving closer to family or support network, it may actually assist in the relocation. Now remember, these relocation issues have nothing to do with grandparent visitation. They're simply with custody and relocation issues. Similarly with parenting time issues. Now again, we're still looking at parent-to-parent relationships, but how it adds in. Ultimately, parenting time is still a decision of the parents. The constitutional right to parent your own child has not been eliminated, probably never will be eliminated. But these cases and these issues that we've been discussing really show the competing interest between the parents and the states. Parents obviously have the constitutional right to parent their child, but all states have an interest in protecting children. So the development in the statutes and the cases and the recognition of grandparents' rights is an attempt to balance those rights. Babysitting quality time, I put this in because this is an issue in a lot of single-family homes and divorced homes, that you'll have one parent using their grandparent or their parents for babysitters, and the other parent often has an objection saying that either they should be with a natural parent or at home. Like we mentioned at the bottom, the right of first refusal, meaning let's say dad has parenting time with his child for the weekend, but leaves for the weekend and leaves the child with his parents. Well, mom will get upset saying that I should have had the right of first refusal, that babysitting, putting your child with a babysitter is not quality parenting time. Now, this is like a new development, the right of first refusal. Some say the parent gets to decide. So if dad has the weekend, if dad wants to leave with a babysitter, he has the right to, just like mom does Monday through Friday. And others say you really shouldn't leave your child if you're getting parenting time. If your time is already limited, it should either be with you or with a natural parent. This is an issue that you should look at if you are contemplating getting a divorce or writing a parenting time agreement. You may want to decide, you may want to put in language about the right of first refusal and possibly even about grandparent visitation issues so you can address it. So I'm going to take a minute to close down and then address some questions. If you have any, obviously put them up into the chat pane, like I said, but just give me a minute. I'm going to shut off the screen and close down the webinar, and then I'll address the questions. I meant to tell you this in the beginning. I don't think I did, though, but when you post a question, I don't think anybody but me sees it. So you don't have to worry about any confidentiality issues. I will not address you by name when I answer your questions. So just give me a second. Let me turn this down and take your questions for you. I'll be here as long as it takes. So put up any questions you have. I have as much time as you need.